Good afternoon, everyone, and welcome to our webinar on introducing maritime law. My name is Prem Gurbani. I'm going to be your moderator for today. With me, my fellow panelists, Zhida and Adam Emiliano. Zhida is an associate director with Helmsman LLC Singapore. I'll tell you more about him later before he comes on. And Adam is the head of Corporate Services and General Counsel of Eastern Pacific Shipping. Again, I will tell you more about him before he comes on with his bit a little later. Now, a bit of housekeeping for today. Today's session is scheduled to last for 1 hour. Please do note that the session will be recorded and uploaded to SMF's YouTube channel. So if there's anything that you want to refer back to, please do go to YouTube and you will find a recording of this session. If you do have any questions, and we hope you do, after you have heard the panelists, can you please submit your questions via the Q&A button at the function bar? And what we will do is we will attempt to answer every question live or in writing. And if we do not manage to answer your question for any reason, please do write to us at the email address that you see on the screen, which is ops@sgmf.com.sg. Let me just first start with telling you a bit about Maritime Singapore. If I may have a slide on Maritime Singapore, yes. What are we trying to achieve today by this webinar? The purpose of this webinar, first of all, is to introduce the study of maritime law and to interest the students in the NUS in the study of maritime law. But why should anyone want to study maritime law in the first place? Well, let me give you a few reasons. What you see on the screen now, you can see that Singapore is actually ranked #1 amongst 15 maritime cities in a global survey. It is the #1 maritime city in the world. It is home to over 140 of the world's top international shipping groups. I'm sure Adam will tell you more about that later. It contributes 7% to Singapore's GDP. In other words, out of the total amount of money spent on businesses and by government and so forth, $7 in every 100 is for maritime. And GDP also means the total amount of receipts that are received by all businesses in Singapore, $7 out of 100 is maritime money. The maritime industry employs 160,000 people in Singapore. Of course, we like to believe that the lawyers are the apex of the maritime industry, but, well, we are part of that, right? But there are so many industries, be they shipyards, be they support services, upstream, downstream, all sorts of things, bunkering. So 160,000 people in Singapore earn their living from maritime, and that's a substantial portion of Singapore. Altogether, there are 5,000 maritime establishments. Again, upstream, downstream, mainstream, you name it, all sorts of things. It's not just ship owners. It is the entire ecosystem, 5,000 maritime establishments. To the next slide, please. There's more about Maritime Singapore. At any one time, there are about 1,000 vessels in the Singapore port. And those of you who take a drive along the East Coast and down by the coast to the West Coast, you can see the number of vessels that are there. I mean, if I compare that scene to what I remember in the 1970s when I was a new lawyer, right? Things used to be very, very different, right? Now, with so many vessels there, it looks like a traffic jam. compared to what used to be the case in the old days. Every 2 or 3 minutes, a ship arrives or departs Singapore. Singapore is connected to 600 ports in over 120 countries. Although Singapore does not produce any oil, you'll be surprised to note that it is actually the top bunkering, meaning top ship refueling port in the world. The Singapore Registry of Ships is amongst the top 5 largest ship registries in the world. Today, the SRS has over 4,400 vessels registered with it. Singapore has been a council member of the IMO, the International Maritime Organization, since 1993. And another fact that you will want to know is that in the world of commerce today, more than 80% of the world's trade is carried by sea, although in a seemingly old-fashioned sort of industry, 80% of the world's trade is carried by sea. Seaborne trade remains the most energy efficient and environmentally friendly mode of transporting cargo. Without it, half of the world would starve and the other half would freeze. Annually, there are more than 130,000 ships that call at Singapore. And seaborne trade has been an important lifeline for Singapore from the time of its founding. More indicators, the next slide, please. You can see that it is a growth industry. Some people say it's a sunset industry, but we know it's a good growth industry. And look at the figures, right? Year-on-year growth for vessel arrivals, 6.6%. Year-on-year growth for vessel container throughputs, 14.6%. Cargo throughput, 14.6%. And bunker sales, 3.7%. So this is May 2021, and we are in the middle of a pandemic. And yet, we have year-on-year growth in this industry, right? So that's an indication of how vital and how dynamic maritime law is. Now, I've given you an indication of how important the maritime industry is in Singapore, and why you should be interested in the study of maritime law. But let me first share with you what my role is here, besides that of being a moderator. I would like to tell you something about the ecosystem, the arbitration ecosystem that exists in Singapore, because at the moment, at my stage of life, I am now an arbitrator and mediator. I started out as Zhida did, you know, young, enthusiastic lawyer, and wandered my way through partnership, wandered my way through all sorts of things, and finally, in the last 10 years or so, close to 70 years old now, I am now an arbitrator and mediator, sometimes counsel, but most of the time, arbitrator and mediator. I started my maritime career in 1978 as a associate to the late Justice of Appeal M. Karthigesu, right? And in the 80s, I set up one of the boutique firms that used to exist at the time. It was called Prem Gurbani and Chong. And that firm later became Gurbani and Co. in 1989, right? Over the last few decades, what I've done is mostly dry work, all sorts of dispute resolution work, trial work, and there has never ever been a dull day. So here I am, right? 43 years later, right? Talking to you, trying to enthuse you and persuade you to try and join the maritime circle. But why? Why should you think, why should you be bothered about maritime law? There are so many other sexy subjects, maybe international property. I'm not saying you shouldn't take intellectual property and so forth, but what I'm trying to tell you is the sexiest subject in town is maritime law. As a result of what I've done over my career, I have had the opportunity to travel to far-flung corners of the world, right? I have friends in most of the major ports of the world. My interest and my influence goes beyond Singapore. I get calls even now every day from people from all over the world, and that is because I have been a maritime lawyer. When I travel, at almost every place that I go, I have a friend because I have either dealt with him, I've either instructed him as a lawyer, or he's instructed me as a lawyer, or I have been an arbitrator, and all of us eventually become friends. So the international nature of maritime work is something that is quite unbeatable. On top of that, they didn't exist in my time when we started out, but there are now career opportunities. I'm sure you will want to know this because it's important to you. Career opportunities now exist for maritime lawyers all over the world. So if you graduate from the NUS Law Faculty and you're a maritime lawyer, the nature of maritime law being international, and if you work hard, you will be able to garner career opportunities, not only in Singapore, but in the entire region, and maybe aspire afield as Europe or America as well, because we have Singaporean lawyers who go to Europe and America as well, right? So that is the other thing. It is not a domestic practice. The practice of maritime law is not a domestic practice. There's also, remember, once you have done 5 years in maritime law, you can then apply to become a specialist recognized by the Singapore Academy of Law. Some of you may know that there are only 2 specialist areas recognized by the Singapore Academy of Law so far. They will develop others, I'm sure, in good time. But at the moment, the 2 areas where you can be recognized as a specialist by the Singapore Academy of Law are construction and maritime law, shipping and international trade. And let me just add, while I'm on the subject of international trade, let me just add that if it is your interest to do international trade when you practice law, you must have a foundation in maritime law, in shipping law, especially in carriage of goods by sea. Because your understanding of international trade will be that much poorer if you do not have a base in carriage of goods by sea and charter parties, right? So I think I might have exceeded my time, right? With that, if I can introduce my first panelist, Zhida Chen. Let me just tell you a bit about him quickly, right? And pass it on to him. His main focus lies in international commodity trade finance, and dry shipping work. He not only regularly appears in the Singapore courts, but also acts as counsel in international arbitrations. He's also qualified to practice law in Singapore and England and Wales. He also regularly advises clients on non-contentious matters, right, ranging from commodity sales contracts and charter parties to UN sanctions. He's proficient in Mandarin. His expertise is much appreciated by Chinese traders, including state-owned enterprises and listed companies. In 2019, he was appointed amicus curiae under the prestigious Young Amicus Curiae scheme, which provides young practitioners with the opportunity to assist in the Singapore courts on novel points of law. He's a former JLC with the Supreme Court of Singapore, and he has joined Helmsman LLC, very appropriately named firm, right? After working for a number of years at a Big Four firm in Singapore. He's won a number of academic prizes from the NUS. He's also got a master's in law in international legal studies from New York University, has been teaching as an adjunct at the Faculty of Law of the NUS since 2014, and has been appointed as an adjunct AP, Associate Assistant Professor, one of the youngest in the Faculty of Law at NUS. So, Zhida, can you please take over?
Thank you, Mr. Gurbani. And hello everyone. Thanks for joining us today. So for today, I really want to just share a bit about how diverse practice can be as a shipping lawyer. Often when I talk to my students and I talk to young practitioners, and I say, shipping is a really interesting area, and their first response to me will often be, oh, but I don't really want to do ship arrest. I'm not interested in doing ship arrests, right? I want to do, for instance, corporate work. But shipping lawyers, we do more than ship arrest. I mean, it's definitely a part of our work. But so for instance, right, if you're interested in doing non-contentious matters, corporate matters, as a shipping lawyer, it's possible to do transactional non-contentious work as well. For instance, reviewing general terms and conditions for ship owners, charterers, looking at sale and purchase of ships, financing of those purchases. So there's work that can be done if you are interested in doing non-contentious work. But of course, on the flip side, there are also contentious work. For instance, charter party disputes when it comes to shipping matters, cargo damage, cargo shortage, and casualties. Now, Mr. Gurbani earlier mentioned dry work, right? Generally, when we talk about shipping work, I mean, it can be divided into dry shipping and wet shipping. So when it comes to wet shipping, what it really means is, for instance, things like collisions between two vessels or three vessels sometimes, collision with berths, wharves, or even vessels damaging, say, underwater features or underwater cables and things like that. Or salvage and general average, basically casualties that occurs at sea, pollution, these are generally classified as wet work. On the other hand, you have dry shipping work, for instance, charter party disputes, bills of lading disputes, and these are generally, some may call it advanced contracts or even advanced torts, where you are really dealing with the, it's dry in the sense that you don't see the vessels in the sea, right? It's really relating to the cargo on board vessels and dealing with contractual relationships and disputes arising therefrom. Now, Wilson, can you go on to the next slide? A bit more about the different types of work that a shipping lawyer may deal with. Earlier, we heard mentioned about sanctions work, and of course, in today's climate, sanctions are a big part of our day-to-day operations. So, as a shipping lawyer, it is not uncommon to come across clients with concerns, with problems relating to sanctions. It could be UN sanctions. So, for instance, if you see in the picture to the left side of the screen, UN sanctions on North Korea. And if your client's vessel, for instance, happens to be shipping sanctioned cargo or cargo that is going to or from a sanctioned jurisdiction, what happens, right? And things like that happen. I mean, as a shipping lawyer, you really never know what happens on a day-to-day basis. You could get a call after office hours and from another part of the world saying, look, I have a problem, right? My vessel has just loaded what might be sanctioned cargo, what do I do? Okay, so that's something that perhaps not all of us would imagine a shipping lawyer to be dealing with. If you look into the middle of the slide at the top, the top photo, it's probably something close to our hearts now. You know, COVID-19. It's been a while now, but the shipping industry is still dealing with the aftermath of the whole COVID-19 situation. So, for instance, if you have vessels with crew who are infected with COVID-19, what happens, right? How do you deal with situations like that? When, for instance, the port authority refuses to let your vessel enter port because one of the crew is infected with COVID-19, and so on. At the bottom, you will see the Hin Leong trading scandal. I don't know how many of you are familiar with this. It's been reported widely in the news in the past, I don't know, few months. Again, as shipping lawyers, partly because, well, predominantly because cargo and commodities are often shipped, transport on board vessels. When there is a trading dispute, including situations where there are defaults of payment to banks, that's when you get shipping lawyers involved as well, because you may potentially want to consider your recourse against the vessels if you hold the BLs, the bills of lading. And across to the right side of the slide, at the top, in the top picture, you will see again something very topical. The Suez Canal, the vessel that was stuck at the Suez Canal, that has caused a long jam in the supply chain. Again, that's, to shipping lawyers, that's just part and parcel of our everyday work, right? Something happens on a far end of the world and it impacts the rest of the world, because shipping by nature is cross-border, right? Especially when it comes to Singapore, we don't really have inland internal shipping within the country itself. Most of our shipping work is really cross-border. It's by nature cross-border, right? And also, I mean, just at the bottom right-hand corner, you see, we also deal with other aspects of work. For instance, where you have a hacker that hacks into the communications between counterparties, requiring payment to be made to, for instance, someone's account that doesn't belong to the person who actually should be paid. So these things, I think, are not what you typically think a shipping lawyer will be dealing with. But this is just to show you how broad the scope of work that we do. I think that's all from me for now, and unless there are any further questions that we can come back to later.
Yes, thank you, Chetan. Okay, let me now introduce Adam Emiliano. Adam is the head of Corporate Services and General Counsel at Eastern Pacific Shipping, with responsibility for all legal, compliance, insurance, and risk matters across the group. He has over 20 years' experience advising on a wide range of practice areas, encompassing shipping and maritime law, corporate M&A, banking, finance, tax, and commercial litigation. Adam holds an MBA from INSHED and a Bachelor of Laws from the University of Bristol. He's a qualified solicitor in England and Wales. Adam, thank you.
Thank you, Prem, for the introduction, and good afternoon, everyone. I think just to pick up what Prem was saying earlier about shipping, it's not an area that most people have at the forefront of their mind, when, especially at university, when you're considering the broad range of subjects that are available and the practice areas that you may want to go into after university. And certainly my career into shipping has not been linear. in that I started my career as a finance lawyer, and then did other work, corporate and restructuring before then going into shipping in 2008 during the last kind of shipping financial crisis. But it is an area that is worthy of consideration, least not because it really is the backbone of the global economy. 90% of all trade is carried on ships, and I don't think many people realize that, but it is a litmus for the global economy. And if you follow what is happening in shipping, it is certainly an indicator of what is happening or will happen in the economy in general. Before going into my next slide and giving you a kind of a brief overview of what it is to work for a shipping company, I think it's important to note that at this point in time, I think shipping is undergoing a kind of overall reincarnation. There's a lot happening in shipping. There's a lot of focus on the environmental impact, and that's resulting in a lot of innovation in shipping, whether that's in the fuel that they burn, in the propulsion systems, and technology on board the vessels to make them much more efficient. And that's something that anyone in the shipping industry is very closely looking at, and it's a very exciting time to be in the industry. If you just go to the next slide. So shipping. I mean, shipping is like any other business in a way. Every business needs to make money. Every business needs to add value, and shipping is not much different. So Eastern Pacific is a ship manager. We manage ships. We manage them for our ship owning group. We have ships in all the major segments, whether that's containers, dry bulk, tankers. And the different segments are slightly different in the way that they perform, but the fundamentals are the same. You own a ship, you own it by either buying it secondhand, or you build it by contracting with a shipyard. You operate the ship, hopefully profitably, and then you sell it, again, hopefully for a profit. And in managing that ship, you need to charter it. That's what generates the revenue. You charter it to charterers, and those charterers are your liner companies, your oil majors, your traders, your miners, usually the people that put the cargo on the ship, and that ship then transports the cargo from point A to point B, and you get paid for it. But in order to get the ship to move, you need to also manage the operations. So put fuel in the ship, put crew on board, make sure that the vessel is in good maintenance and repair. That's what we do. And that's what you see on the pie chart here as the shipping related transactions, right? So you have the charters, which is, the rental of the ship. You have shipbuilding when you construct it. You have financing, which is obviously important in buying the ship. And you can also have various joint ventures with parties, either for financing or as part of a pool to get the economies of scale in a particular segment. Alongside that, there is obviously a lot of disputes, as with any other area. There are disputes in the charter parties for various reasons, where terms are perhaps not as clear as they should be, payment disputes. And most of these disputes as a ship owner are covered by insurance. So inevitably, there is insurance aspects to any litigation. A large part of what we do today, given the landscape, is sanctions work. Shipping has been a focus of attention of a lot of regulators, at least not OFAC, because they have been using it as a means to bypass sanctions. How does Iran get goods? How does North Korea get goods? There are various kind of elusive practices that some ship owners engage in that has resulted in a lot of attention. And all ship owners, ship managers, or anyone in the industry will be focusing on sanctions because of the consequences of not doing so. Other areas, as you may know, data protection, antitrust, bribery, obviously are regulatory areas. And there are, as any business, we have other areas that we deal with, you know, employment, tax, procurement, IT. All these are areas that you'd expect any business to have outside of their core area of service or goods. And so that pie chart, I think, represents all the things that you would do working internally in-house as a ship company. So people don't realize the breadth of the work that you necessarily are involved in working for a shipping company. And I think that pie chart tells a very different story. The difference between in-house and private practice. Well, again, you know, working in-house, your employer is your client. You're acting for the benefit of the company, and everything you do is in furtherance of the objectives. You're there as a risk manager. You have to balance commercial realities against risks. And in doing so, you obviously leverage specific advice using law firms, consultants, in areas where you need specialist advice. And so there's a very close interaction between a company's in-house team with specialist law firm practices. Now I just want to give you an example of a recent case, well, not so recent, a few years ago, that EPS was involved in, interesting one in terms of a dispute. This is a kind of news article in the trade winds some years ago involving Eastern Pacific. We were buying a ship. The ship was being sold by a bank that had enforced its security over the ship when the company, the group, Hanjin, had gone bankrupt. And we were negotiating with the bank for the acquisition of this ship, as you can see. This was at a time where the Capes, this was a Cape, so it was a dry bulk vessel, was pretty much at the bottom of the kind of pricing range. So we thought that was the bottom of the market, and the prices would only go up. So it was a very good, attractive price, $17 million. We had agreed all terms with the bank for the acquisition. There were no conditions. The only thing left to do was to sign the contract. Unfortunately, the bank didn't think that we had a binding contract because we hadn't signed it. As you all know, in studying law, you don't even need a written contract to have a contract. And the fact that it hadn't been signed does not mean that you don't have a contract. And the bank, nevertheless, was negotiating with another party who had offered a slightly higher price for the vessel. We were obviously keen in buying the ship. We thought the market was going up. There was a particular upside in acquiring it. And so we commenced legal action. And we obtained a worldwide freezing order, which covered both the sale of the vessel and all the receivables that they may receive from any sale that they decided to do to a third party. That injunction was enforced in various jurisdictions, in Korea, in Panama, which was the flag of the vessel, preventing the transfer of title. And at the same time, we engaged the media in Korea. This was a Korean bank, in order to put pressure on the bank to come back to the deal and sell the vessel. That had the desired effect. I think what happened was that the restructuring team at the bank was relieved of their duties, and the bank did come around and sell the vessel to us. Unfortunately, that wasn't quite the end of the story, because Hanjin, which was a bankrupt shipping company, had a lot of unsecured creditors. And so one of the creditors had filed writs in various jurisdictions against all the vessels of Hanjin, including this one. And they filed those writs in South Africa. So when we acquired the vessel and we did our writ searches, we found that there was a writ against the vessel in South Africa. And we then had to go to South Africa to challenge that writ before the vessel would call there and get arrested. And this led to a pretty interesting point of law as to whether a change of ownership between the filing of a writ and the arrest of the vessel would preclude the claimant from arresting the vessel. And we were able to win that argument, and the vessel was taken out of the list of vessels over which they had filed writs. Another vessel that was in a similar position, it was a C-span vessel, had unfortunately called to South Africa and found itself arrested, and a court in a different province of South Africa ruled differently on that particular point of law. And so the point of law was appealed in the Court of Appeal in South Africa, and ultimately came to the same decision as the court found for us. So that just gives you a kind of overview of the nature of the disputes. I think what I find attractive about shipping, and I have been in other areas as well, is that you have both the depth of law in terms of shipping. Shipping law is a very rich, deep area of dealing with actual law, right? There are other areas that, yes, you need to know some principles, but on the day-to-day stuff, you probably don't need to refer to case law and look at particular points of law in the case law. Shipping is not. So if you're interested in getting your hands dirty and looking at interesting case law to support arguments, shipping has that. But at the same time, it has lots of other aspects. There is transaction work as well, either sale and purchase or charter parties or joint ventures. So there's a lot of corporate work, if you like, or M&A work as well. And you have the financing as well. So you finance the vessels in the same way as any other asset. So within one single area, you can pretty much do the full spectrum of work and not necessarily focus in one narrow field like intellectual property, which tends to be quite country specific. If you're doing intellectual property in Singapore, then that tends to be focused on the local law, and the intellectual property regulations or laws in another country are different. So it's also very international. You can apply the experience that you get in shipping, use that to work in other countries. And so it gives you a very wide range of opportunities, not just within shipping law, but ancillary practices like insurance, for example. So my advice is, you may not want to go into shipping right away, but don't, if you do, it's a very exciting time to go into it. If you want to consider it later, it's never too late. I myself went into shipping quite some time after qualifying. So yeah, with that, I think I've probably exceeded my time as well. So I'll hand back to Prem.
Thank you, Adam. Thank you for that insight. Now we have time for questions, and one of the questions that has been posed, I think, is, from a point of view of a student, how often do I need to board a vessel? Is it suitable for people who might be seasick? Okay, I think you have heard both speakers. You have heard Zhida and you have heard Adam. The practice of shipping, you can be in many subspecialties, or you can do all of them, right? But the subspecialties, if I may just summarize it, say wet work, dry work. Wet work meaning it's actually contractual work, but it is a subspecialty of contract, right? So you do carriage of goods by sea, you do charter parties, that's dry work. And then wet work, collisions, stranding, sinking, and so forth. Then you have finance, as Adam's just said. You have finance, you have sale and purchase. That illustration that he just gave you just now is a sale and purchase dispute involving ships and ship sale and purchase. Then, of course, there is another area, a very specialist area called marine insurance, right? And I think if you are good in marine insurance in Singapore, or you're a good marine insurance lawyer, you are worth your weight in gold, I can tell you. You are so rare. You know what I mean? So there are many areas. So obviously, if you do wet work, you will have the opportunity, and you will be expected from time to time to take statements on board ship and so forth and all that. But not if you do dry work, right? Dry work is more contractual disputes. Not if you do finance, not if you do sale and purchase, not if you do marine insurance and so forth. So there are one or two subspecialties of shipping where you will be expected to board ships. In most of them, you need not board ships. And as far as arrests and such procedures are concerned, most of them are actually done by people who are trained in the firm to go and do these things. Of course, you can always look for an adventure and go out there yourself, as I used to do. We used to say, well, boy, there's an arrest, I want to go. Let's make a day out of this and get on board there and then have a few beers with the crew and so forth. It was an adventure to us, but you don't have to do it. So those are things that concern students. So I thought I'll tell you these things. How do you decide? There's another question here. How do you decide between working in a shipping company or law firms? Well, when you start, I would always advise that you start in a law firm. That's my personal advice. You start in a law firm. After you have built up three or 5 years or whatever of practice, then you will be able to tell whether you want to continue in that environment, or you want to try something else, or you want to try some other aspect of shipping, or go in-house, right? But it's not something that you can tell straight away. Of course, if you have done your research and you have friends who are in shipping, you will know better than someone who's just come out of university, but generally it's best to get a base in practice. Yeah. There's another question. How can I improve my chances of receiving a training contract as a maritime lawyer? Well, you can improve your chances of receiving a training and contract as a maritime lawyer by first doing maritime law, right? By first doing maritime law. There are so many electives offered by the NUS. Choose one of the electives. The basic electives, and we have discussed this amongst ourselves, the panelists, the basic electives, the starting point is carriage of goods by sea and charter parties. And then you move from there to all the others, right? But that's a basic elective. So if you do, you do one of these electives, you will definitely improve your chances of securing a training contract. The other thing I should tell you, being from the SMF myself, is that the SMF has initiated a scheme where we have law firms registered with us who are able to offer training contracts, and they tell us every year how many training contracts that they're willing to give out. So we can arrange interviews for you. Of course, you have to satisfy their requirements, but generally, at least this is a starting point. All you have to do is to contact the SMF, Singapore Maritime Foundation, right? You can go to their website, you can get our contacts, right? And we will assist you in getting these training contracts as far as we can. We can even assist you with internships. We also have a register of firms that are interested in giving internships to students who want to pursue maritime law, and so we can help in that regard. Let's see. What is the ideal route for entering the shipping industry? Would employers be on the lookout for certain fundamental subjects, modules taken in university? Well, yeah, well, as you can see, and you probably have done your research, the NUS has got 11 maritime law electives. 11, okay? And I think I've answered that question in some way by saying, well, if you have to choose between the electives and you don't want to take too many of them, then it'd be a good idea if you start with carriage of goods by sea and charter parties. That's my personal opinion. I think Zhida is also on that same line, and Adam believes in that as well. And then you can go on to the other things. Does that answer the question? Right. There's somebody in chat instead of Q&A. Let me see. Right. Right. Okay. Yeah. What differentiates maritime law from other areas of specialization? I think Adam has said something about that. It is, and I've said something about that as well. It is something that will always interest you. When you come to work, you will never have a dull day. It will always be something else. It will always be a problem that somehow you have never thought about, and you need to think about it again. I still struggle with it after 40 over years. I still struggle with some of these, how inventive some people are and how inventive some ship owners are, particularly certain nationalities. I won't name those. So, and it's incredible how resourceful they are, All right. Another question, can I ask how important it is to learn the public law side of things, law of the sea or world trade law? Obviously, it is important if you have an interest in that area, right? And the law of the sea is one of the electives that is offered. If you want to seek a career in government, and you want to seek a career in the foreign service, right? I think that the law of the sea will hold you in good stead. Will hold you in good stead. As you know, we often have disputes from time to time that involve the law of the sea. And we often have, the Singapore government often participates in world trade law. So public law is important if you intend to follow a certain career. But if you are a commercial lawyer, this is my personal perspective, if you want to be a commercial lawyer, then I would advise that as far as the electives are concerned, you choose something that you start with the basics, right? And then if you still have an interest and you want more areas to go into, then by all means, later you can go into the law. You know, there's nothing stopping you. It's a lifelong journey. I'm still learning. You know, some of the kids I teach, or in SMU, for instance, they ask me things. They stump me every week, right? They stump me every week. So it's a learning thing. It's not a static thing. This is one of the things about shipping. When my daughter did shipping in the NUS, and that was in the middle of what, 2005 or 2006, right? She asked me, you know, Dad, what do I do with these shipping books now that I'm finished? I said, throw them away or give them away and sell them down the line to the next guy. She said, what? Why? You know, I said, well, they're going to be useless in a couple of years. He said, what do you mean? You mean to say they're going to be useless? Yes, I said they're going to be half useless in a couple of years because it is so dynamic that you need to update yourself constantly. So don't keep these books, pass them on, sell them down the line to the junior, right? And you will need to update your library as you go along. That's how dynamic it is. Let's see. Is it not uncommon for shipping lawyers to change jurisdictions they are practicing from Singapore to London to Dubai? Actually, it is quite common nowadays. It may have been uncommon many years ago, and in fact, those opportunities were not even available to me. But they are certainly open to young lawyers like Zhida, for instance. If he wanted to move to some place in China and open a practice, there would be absolutely no problems for him. There you are, he has all the opportunities in the world, right? Which we never had. So there are lawyers who do move from Singapore to London and vice versa, and to other jurisdictions around here. There are lots and lots of shipping lawyers in Hong Kong that are actually from Singapore. Right? Who started in Singapore. I hope that answers your question. Right. Let's see, were there any further questions? What personality traits are important to be a maritime lawyer? Personality traits. Now that's a tricky question, right? I suppose be like me and talk a lot. No. All you need is an interest. All you need is an interest, and an interest in people is helpful. If you get along with people, you will find the shipping industry a great place to be, because we all relate to each other. And not only do people in the industry relate to each other, amongst lawyers, we relate to each other greatly, because we have a fraternity. Most of us know each other, right? And because most of us know each other, we're able to accommodate each other's schedules. We're able to get indulgences from each other that we wouldn't normally be able to get from someone else. So it's a great fraternity. You can become part of the fraternity. In fact, once you become a student in maritime law, we'll encourage you to join the Maritime Law Association, right? where you can hobnob with all the practitioners. They can teach you. It's all free. It's all free. For students, the Maritime Law Association of Singapore is free, right? And you can communicate with the Singapore Chamber of Maritime Arbitration if you're interested in arbitration. You want to watch an arbitration and find out what opportunities there are to learn from arbitrators, so that they can bring you in. They can bring you in with the consent of the parties, of course. They can bring you in, and then you can assist the arbitrators. You can become a tribunal secretary if you're really interested. Make yourself a nuisance, and you will learn. This is the way I learned it. I made myself a nuisance. I kept hanging around my partner's room and said, "Sir, I want to do this. So where are you going?" Right? So you learn. So, can I follow you? So once you do these things and you make yourself useful, you have tremendous opportunities. Okay, Adam, one for you. Can I ask Adam his opinion on roughly how many years of experience in private practice is required before moving in-house? And what specialties would put one in good stead for those opportunities?
I would say minimum of 2 years. I think about the 2-year mark is the level where you've gotten enough depth of experience in a particular field that you then become confident in that field and be useful in any in-house role. So 2 to 3 years, I think. Yeah, you should definitely aim for that. I think I agree with Prem, who said earlier that it is useful to start your career in private practice, primarily because they do have all the resources there to give you the depth of experience, which a lot of companies don't. If you think about their know-how, their precedents, their seminars, the on-hand training, you have the opportunity to do a particular piece of work a few times, and you need that to get the experience. When you move in-house, you're moving from being a specialist to a generalist, and it becomes harder. You are juggling lots of different things at the same time, and having that good foundation, I think, will be very helpful for you and your career.
There's a question here. What is the most interesting part of shipping maritime law for you? Zhida, you want to try that?
Well, it's a difficult question, really. I think, very often I start by thinking, I think dry work is the interesting part. But then, in fact, I was just thinking recently, I've been starting to do some wet work, collisions and grounding and things like that. And really, it's quite interesting as well. So to ask the question, what is the most interesting part, I think, is the fact that every day is changing, right? Every case is a new case. You almost never look at the same case twice. It's just that novelty and the ability to help your clients solve their problems. That's I think what is interesting about shipping and maritime law, the diversity of it. Yeah, it's always kept fresh and different.
Thank you. We have a question in the Singapore Maritime Law landscape, a tricky question. Which firm has the most dominant role in the market? Okay, without endorsing any firm, I mean, there are 3 or 4 big players there, but there are many boutique players. Okay, and that is not to say that the boutique players are any less competent, or they handle a level of services that is less desirable. Not at all. I mean, Zhida, for instance, comes from one of the big 4, right? but he is in now in a firm, a sort of a breakaway from the Big Four, right? Although not entirely, because there are now new additions and so forth, right? Where they offer a service which distinguishes itself from the Big Four. There are many constraints in a large law firm that don't exist in a smaller law firm. So some people prefer to work in a smaller law firm. Some people prefer to work in a larger law firm. I started in Allen and Gledhill, but being the sort of character that I am, the maverick that I have always been, right? I preferred my own environment. I preferred to call the shots, right? So as a very young lawyer, I said, well, if I have a base of clients, I'm going to do this for myself. I'm going to be my own boss. So, you know what I mean? So there are things you can do, right? And there are different ways you can do it. So long as you are pursuing, you're getting the work that interests you in the field that you have chosen. I hope that answers the question. Okay, this is an interesting question. Thank you for answering the previous question. Could I also ask, what is the proportion of arbitration to litigation in maritime law? I think I can answer that because in charter parties, you'll be very surprised to see that a dispute is to be referred to a particular court. You'll be very surprised to see that. It is almost 100% arbitration, right? And you will see that most of the charter parties that you see in Singapore, it will be either arbitration London or arbitration Singapore. And more increasingly, it is arbitration Singapore, more and more so, because we are really pushing and plugging for arbitration in Singapore, right? So the proportion of litigation to arbitration, I would say, I may have a view on this also. I would say 80-20, even 90-10 in favor of arbitration. Hardly any disputes go to court in maritime law. If they are fought out, before arbitrators. So if you are interested in arbitration, and you know arbitration is a growing field, if you are interested in arbitration, then by all means, that's an additional reason why you should think of maritime law, right? Okay, now we have time for the last two questions, if there are any. Well, okay, if there are no further questions, then we can conclude today. And in conclusion, may I say thank you for attending our webinar. And I hope to see as many of you as possible taking up maritime law electives and eventually becoming part of our maritime law community. Thank you very much.